Hello everyone. Let us look at some of the definitions under the Indian Evidence Act of 1872. First of all, what is a court? Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. This is a specific meaning of the court under the Evidence Act. The next important definition is what is a fact, because in the Evidence Act we are concerned with facts and only facts. So what is a fact? Fact means and includes anything, any state of things or any relation of things which are capable of being perceived by the senses. Secondly, fact means and includes any mental condition of which a person is conscious. For example, the illustration says that, for example, when we see that some things are arranged on a place or on a table, that arrangement is a fact. Or a man heard something, it is a fact. A man saw something, it is a fact. Whatever he perceives by his five senses, it is a fact. Or if he is mentally conscious of something, for example, he has a reputation, it is a fact. Or he said something in a particular sense, or he had an intention, or he said something in good faith, or he did it malafide with a bad intention. All these are facts according to this definition. This is the interpretation clause of the Evidence Act. Next, coming to the word relevant. What is relevant has to be produced as evidence and nothing else. So how do we say that this is a relevant fact? This is a very simple definition. It says that one fact is relevant to another if by itself or when it is connected with another in any of the ways referred to in this chapter, that is of the Evidence Act, relating to the relevancy of facts. So when this second chapter consists of only the circumstances in which the facts may be called as relevant, and only those facts are called as relevant which are contained in this chapter. That is the only definition of relevant. What is fact in issue? Now, when there is an issue before the court, which are the facts which can be said to be facts in issue? Facts in issue means and includes any fact from which, either by itself or in connection with any other facts, the existence, non-existence, nature or extent of any right, liability or disability which is asserted or denied in any suit or proceeding before the court necessarily follows. There is an explanation which says that whenever under the provisions of the law relating to the Civil Procedure Code, the court records an issue of fact, then that fact to be asserted or denied in answer to that issue, that is called as a fact in issue. So let us say A is accused of a murder of B. Then what is the fact in issue? Whether A has caused B's death, number one. Secondly, whether A had intended to cause B's death. Then whether there was a grave and sudden provocation to A from B, because of that he caused B's death. Or there could be another fact, that is at the time of doing the act which caused B's death, A was suffering from some unsoundness of mind, or he was in such a mental condition that he was not having the knowledge of what he is doing. These are all facts in issue before the court. So facts in issue are facts out of which some legal rights which are asserted, or some extent of that right, or that disability or liability which is asserted or denied is following from those facts, then they are called as facts in issue. Next definition is relating to the document. What is a document? A document means any matter which is expressed or described upon any substance. It doesn't say paper. It says anything described on any substance by means of letters or figures or marks, or by more of these means, one or more of these means, which are intended to be used or is used actually for the purpose of recording that matter. So we see that document consists of everything. Even materials are taken as documents under this particular definition. Suppose there is a stick or there is a stone on which some marks are there and that is pertaining to the fact in issue, that is called as a documentary evidence only, because it is a document, it is something which is described or inscribed upon any substance. So this is the meaning of a document. Then what is evidence? Evidence is something which is produced before the court. We know that. So what is the definition according to the interpretation clause of this particular act? So evidence means and includes all statements, number one, all statements which the court permits or allows or requires to be made before it by witnesses. Either the court should permit that or it should require that to be presented before it by witnesses in relation to matters of fact in issue, that means fact under inquiry, and these statements which the court allows or the court permits or the court requires, these statements are called as oral evidence. Secondly, all documents including electronic records which are produced for the inspection of the court, these are called as documentary evidence. So according to the Evidence Act, only two kinds of evidence is described, that is oral evidence and documentary evidence. So can we say that some other evidence, for example, when we describe evidence, we say this is primary evidence, or we say this is secondary evidence, or we say this is circumstantial evidence, this is direct evidence, or this is material evidence or real evidence. When we look at this definition, we find that all these kinds of evidence are included and classified into these two classes only, that is oral evidence and documentary evidence. So whatever the court permits to produce before it, or whatever the court asks the witnesses to bring before it, that is it requires the witnesses, that is evidence. Or whatever documents are given before the court for its inspection, they are all evidence according to this definition. Then there are three words: proved, disproved and not proved. So what is the meaning of proved? So when we say that this fact has been proved before the court, what do we mean? A fact is said to be proved when, after considering all the matters in front of it or all the circumstances which has been looked into by the court either believes that fact to exist, it believes it to exist and it is satisfied, so it is proved, or it considers that existence of that fact is so probable that a prudent man, if he would have looked into these circumstances, he would have, under the circumstances of those particular case, acted upon the supposition that those facts existed. Then we can say that if the court thinks in this manner, then that fact is said to be proved by the court or proved in front of the court. When we speak of disproved, what is the meaning of disproved? This is just the opposite of the proved. A fact is said to be proved when, after considering all the circumstances or matter before it, the court either believes that that fact does not exist, or it acts upon or considers its non-existence so probable that any prudent man, if he was given these circumstances, or it considers that any prudent man, if it would have put before that prudent man these circumstances, that man would have acted upon the supposition that it does not exist. So if that was convinced before the court, that means if the court was convinced that the person has to act upon the supposition that these facts do not exist, then that is a fact which is disproved before the court. So proved and disproved, they are just contrary to each other. Then what is the meaning of the word not proved? We say that the fact is not proved when it is neither proved nor disproved according to these definitions. So this is the meaning of the terms under the Evidence Act. Let us see what India means. So India means the territory of India excluding the state of Jammu and Kashmir. That means Evidence Act applies to all the whole of the territory of India excluding the state of Jammu and Kashmir. That is the definition under section 3 of the Evidence Act. This is called as the interpretation clause of the Evidence Act. So when we look at all these definitions, we find that there is a particular meaning to each of the words under the Evidence Act. I hope you have learned something from this video. If you have liked it, please share it with anyone who you think would be interested. Please leave your comments and I would be happy to reply to them. Do subscribe to get more information on everyday law and legal studies. Thank you.